I'm David Warren, co-founder of Bridgeford Trust Company and chairman of the board. And we are thrilled to have you participate in another webinar that we produced. We're very excited about the topic, primarily because of the evolution of Bridgeford over the last 8 to 10 years. We've developed a pretty powerful and passionate interest in serving the international community. And as I'm sure most of you know, who participated in the webinar, that there's tremendous interest in the United States, and there has been now for many years for a whole myriad of reasons. And Bridgeford, recognizing that, and in conjunction with our passion for modern trust law, particularly out of South Dakota, we found that we were perfectly situated to be of use to international families coming to the United States. It's great to see so many familiar faces from really around the world participate and sign up for the webinar. It's always great to know you're listening and watching, and although we can't currently be together face-to-face, sharing a glass of wine or a cup of coffee, know that we look forward to a time when we can do that as restrictions lift and the world kind of gets back to normal. But again, the focus today, the United States is unequivocally the international trust jurisdiction of choice, primarily because of privacy, asset protection, and tax planning opportunities, again, fueled by the engine of modern trust law, which as I've said earlier, we are wildly enthusiastic and passionate about. And over the years, certainly national media, international media has picked up the idea of the United States becoming, a tax haven or a secrecy haven. The United States has been called the new Switzerland, largest tax and secrecy havens in the world. People get nervous, of course, by that word haven. They get nervous, and we all should get nervous about secrecy, and we should get worried about the idea of tax planning versus tax evasion. What we do in South Dakota, what we do at Bridgeford is certainly not tax evasion or secrecy. It's tax planning and it's privacy, and it's an important distinction that we will talk about as we spend the next 50 to 55 minutes together. But regardless of the language that we use, whether we use haven or whatever, the point is the United States has become, without question, the leading jurisdiction in the country, or rather in the world right now, and also without doubt, South Dakota has become, and I would argue has ascended over the last 4 or 5 years, to really becoming the jurisdiction of choice for U.S. jurisdiction anyway, for a very good reason. So those of us who have been working in international space for as long as we have, we know the reasons. We know why people are coming to America. They get married, they come here for education, there's business activity. And I've always get interested in the conversation because there's this presumption that if somebody wants to come to the United States, somehow they're bad actors or they're nefarious by nature. And I think that's unfortunate. I think perhaps in the last 4 years it's been amplified by politics. But it's not been Bridgeford's experience at all. Just because somebody wants to avail themselves of the stability and power of modern trust law in the United States doesn't make them bad by definition. Just because their skin may be a little different color doesn't make them bad actors by definition. And I think that's something that we're acutely aware of, probably now more than ever, coming in off the heels of a turbulent 4 or 5 years in the United States. We talk about tax and privacy issues. As I said earlier, it's tax planning. It is not tax evasion. That's two very different concepts. There are very compelling aspects to planning that don't even approach tax evasion, that are all perfectly legal. We'll talk a little bit about that. Privacy is a real hot topic right now and has been for years. Distinguishable from secrecy. Bridgeford, or rather, South Dakota has been called sort of the new Switzerland a few times. Well, some would say that denotes a negative connotation. I think that we need to be real clear about what we talk about when we talk about privacy in the United States versus secrecy, because we're not talking about secrecy. We all know the damage that the Panama Papers did many years ago to the question of stability in terms of the maintaining and protection of private information around the world. And Panama Papers isn't the last example of personal private information becoming a part of the public record, if you will, and there's a presumption, and I think with good reason, that the United States infrastructure is stronger and has more ability to protect information from being hacked and disseminated. Asset protection continues to be red hot, I have to say, in my career both as a practicing lawyer and now as an owner of a trust company, it's fascinating to me to see the evolution of asset protection go from being an offshore-only solution to now not only a U.S. solution, but becoming a worldwide solution, that is the United States as an asset protection jurisdiction. The uncertainty of the world right now because of the pandemic and government instability is an issue. And I think, again, that brings the United States into sharper focus relative to it being a jurisdiction of choice for families from around the world. We're all familiar at this point with the Common Reporting Standard. We certainly don't need to spend a lot of time on it. It's been around. It's been the subject of many seminars for the last couple of years. But the reality is it continues to be a driver. It continues to be something that is on people's mind. It continues to be not something that the United States participates in. And it gets to the question of privacy. Certainly there's many other reasons why, and if CRS avoidance is the reason why people are coming to the United States, and Bridgeford will not work with them, as I'm sure most of you will not. So we need to be cognizant of that, but we also have to be realistic to understand it. It certainly is a factor in the worldwide community right now. We understand the distinctions between CRS and FACTA. Again, these are not new topics, but topics at least to set a bit of a foundation as to how we got to where we are here at the end of 2020 with respect to the extreme interest in U.S. trust solutions. We understand the clear differences between the two. Of course, the CRS applies to really the worldwide community. FACTA is the U.S. solution. Both are aimed at weeding out nefarious actors and catching dirty money. Both are extraordinarily effective and in many respects protects the integrity of trust systems and banking systems, and that's why they're there. And we all want them there, particularly Bridgeford and South Dakota trust companies, because again, we are not involved in tax evasion, we are not involved in secrecy, but what we are involved in is working with families that are legitimate, that have not a nefarious intent, and we're proud to be what we believe a leading provider in South Dakota in trust services for international families. This has always been a guiding light for Bridgeford from the very beginning. The choice of a state in which to establish a trust is as critical as the decision to create one. And quite frankly, every time we talk and present, I like to look at this quote because it reminds me of really the very genesis of why we launched Bridgeford in the first place. Initially, it was about U.S. jurisdiction and which state was the most powerful, but really it's become a worldwide conversation. Not only now is the choice of a U.S. state, which is vitally important, but now it's also country in a way that wasn't on the forefront when we launched Bridgeford in the early days. And so trust situs selection is of paramount importance. We've roughly identified why the U.S. is so powerful right now, and we want to transition to really the states in the United States and sort of the race within the nation to be the top trust jurisdiction. Of course, there are magazines like Trust in the States magazine and very smart attorneys like Steve Oceans and others who examine these states unequivocally over the last 10 or 15 years even. It's always been South Dakota, Delaware, and Nevada and Alaska. And again, that's Trust in the States magazine. That is commentators from around the country and around the world that really have made that observation. I asked the question, Wyoming, and I purposely put a question mark there because I continue to be somewhat perplexed as to why Wyoming is talked about in the context of top-tier U.S. trust jurisdictions, particularly given where they fall in rankings, not only our own objective ranking, but frankly, objective rankings of others from around the country. And we're going to explore that. Because I think there's a reason for it, but I suggest it's more marketing than it is of real substance and real value add. So when we talk about the comparative factors of what distinguishes one jurisdiction over another, of course the issues that are analyzed or whether a state has asset protection and how strong that is compared to other states. Of course, Dynasty Trust, which is an extremely important driver for international families, and we will talk about that later. But that perhaps may be one of the largest drivers from a tax planning perspective in conjunction with asset protection and privacy. We'll talk a little bit about taxation with respect to when a international family becomes part of the U.S. tax system, which, as most of you know, is usually not the objective. But nevertheless, should an international family become part of the U.S. taxation system, there are very compelling tax planning tools that you can use out of South Dakota that can minimize taxes on virtually every level, federal and state. And modern trust laws, I can tell you, as we've evolved and become a real player, if you will, in an international space, these modern trust laws available in top-tier trust jurisdictions, particularly South Dakota, has been a huge driver for international families, because there are things we can do in the United States and in particular South Dakota, that really didn't exist when I was in law school back in the late 90s. So domestic asset protection, we know that there's a lot of reason why people are shying away from the Cook Islands and the Bahamas and Nevis and all the other traditional, quote, offshore trust jurisdictions and coming to the United States. Domestic asset protection has been becoming very powerful. These trusts are self-settled, which means that, of course, the settlor can access income and discretionary distributions and still become available, or rather asset protection still available to them, which is very powerful. And it's interesting, as we know, most states don't have asset protection. But what's interesting to me is over the years, these 4 states have consistently been considered to have the strongest and most flexible and really most powerful asset protection statutes in the country. It's interesting because I remember being a part of debates at Heckerling and other conferences where we would be a part of or speak, and there'd be a debate as to whether or not asset protection in the United States works, and if in fact, is it true that you should really go offshore rather than come to the United States. And interesting, that argument has kind of gone away because of the myriad of influences that are impacting the world community. And now there's become, I think, a much broader acceptance that U.S.-based asset protection works. There's case law, particularly out of South Dakota, that makes it very clear, out of South Dakota at least, that the court system will not pierce these trusts. Of course, the case I'm referring to is the Cleopatra case. Very powerful case, very important case, making the point that asset protection is powerful and is driving people from around the world into the United States. We talk about the devil's in the details, of course, when you compare these statutes. It's very, very important, in my view, to understand fraudulent conveyance, which is really a fancy way of saying look back, and to compare. For years, Delaware was considered a jurisdiction of choice. I think that's before South Dakota, Nevada, and other jurisdictions kind of pulled ahead and became quicker to change their laws, really in an attempt to be more attractive, quite frankly, to large families domestically. But of course, that applies now more than ever to international families. And so when you look at South Dakota with a 2-year look back versus Delaware at 4 years, it's compelling. 2 years is 4 years is a long time to wait until you actually have the asset protection that you want and get to a point where your assets are protected by these powerful state statutes. I point out Wyoming is 4 years. That's another data point that makes me pause and wonder why so many people think Wyoming is such a strong trust jurisdiction, particularly in the international space. I have to say I'm constantly surprised when I used to be able to go to conferences before the pandemic of just how much people talk about Wyoming. But even at this data point, it's certainly not the strongest of jurisdictions for asset protection. There's no case law on it, and even when you add the concept of an unregulated trust company, you even wonder how these asset protection trusts could even be protected. But we'll get to that in a moment. So getting back to the idea of this mean, nasty, negative word of haven, let's go back to it for a second. The reason why the United States earned the title of the best tax haven is that its trust law allows for the indefinite suspension of estate tax over many generations, whereas other jurisdictions can't. Forbes magazine made that observation. It references something I said earlier about the tax play that is available in the United States. It's tax planning. I have to say again, it is not tax evasion. And of course, we're going with this is the concept of the Dynasty Trust. In the United States, there was an arcane rule that actually, frankly, exists in more states than you'd imagine still, called the rule against perpetuities. It basically made a definitive end to trusts, which meant that at some point these trusts were going to be subject to taxation, or at least I should say the assets within the trust. However, as time passed, and South Dakota was the first in 1983, they abolished the rule against perpetuities because it was really an industry-driven answer. The reality is large families didn't understand why they shouldn't be able to have a trust to live forever. South Dakota agreed, was the first to agree, and that cleared the way for what we now call a dynasty trust, which, as so many of you know, allows these trusts to live forever, meaning they should never be subjected, the assets should never be subjected to taxation, at least in the United States. It's important to draw some distinctions here. Not all dynasty trust states are created equally. It's important to understand that in some states, like Nevada, there's a question about the constitutionality, state constitutionality, of even amending or abolishing the rule against perpetuities, which they have not done. They've only elongated it. Steve Oceans, which we'll talk about later, has done a chart for at least the last 8 years, comparing dynasty trust jurisdictions. And consistently, South Dakota has been number one in that very objective analysis for very, very good reason, which we'll talk about at the end. State taxation, this is important in so much as a international family decides that it wants to have its assets or decides it wants to make itself part of the U.S. tax system. Of course, there's a mechanism around that, which is, of course, not tax evasion. It's tax planning, and that's called the Foreign Grantor Trust, which we will get to later. But to the extent that an international family decides for whatever planning reason that it's okay for them to be subjected to the United States tax code, there are a myriad of very powerful tax planning tools that can avoid taxation of undistributed income in a properly established trust in a jurisdiction like South Dakota that does not have state tax. That's supported, of course, by the Supreme Court case called Kastner, which is a little over 2 years old now. Actually, I'm sorry, a little over 1.5 years old now. Has really been a proverbial game changer. I don't particularly like that phrase, but in this instance, it really was a game changer, providing legitimacy and affirmation to what we all believed in the industry, that another state shouldn't be able to tax trust income generated in a state that does not have state income tax. Very powerful. Incomplete non-grantor trusts continue to be very powerful. That's a way to avoid state capital gains tax, a very sophisticated planning tool. Community property trusts, also very powerful, another way to avoid capital gains over the long term by treating property within these trusts as community, availing families of 100% step-up in basis at the first of them to die. And the reason why I'm taking some time to talk about this, because in many respects, the planning that we are involved in for international families is to actually keep the trusts out of the U.S. tax system. But again, the reason why we're talking about the United States as, quote, a tax haven, much to the chagrin of lots of people, because that word, again, carries negative connotation. But the reality is, just by choosing the correct state for an international family that finds itself inside the U.S. tax code or governed by the U.S. tax code, there are extremely powerful and compelling moves to make to avoid all kinds of taxation legally. Again, not tax evasion. This is tax planning. This is all perfectly legal. Most of these strategies have been looked at by the IRS and are the subject of private letter rulings. So none of what we're talking about today, none of what anything Bridgeford ever talks about, for that matter, is at all approaching tax evasion. And again, that's a point that I think we need to continue to make in order to really uphold the integrity of the U.S. trust system as a whole, which again, we'll talk about a little bit later. But just by simply selecting the proper trust jurisdiction in the United States has this kind of power. Let's talk about secrecy and privacy and what the differences are. We found this quote also in Forbes. For reference in planning, secrecy has historically meant that no one, not even the government, sees your affairs. Privacy has historically meant that the public can't see your affairs, but the government can. The days of secrecy clearly are dead. So we talk about privacy now. That's what we're about to talk about. We're going to talk about why South Dakota's privacy provisions are so powerful. And we're going to juxtapose in very stark terms why what we do in South Dakota, what we do in the United States, is not secrecy, and also explain why we will not be involved with individuals who come to us who are looking for secrecy. Two very separate concepts that we need to make clear, again, to protect the integrity of the U.S. trust system. So trust matter privacy, it matters very much. It matters not only to U.S. people, but more importantly to international people who, because of certain international reporting requirements, they can't control the release of their personal information. In the United States, particularly really only South Dakota, you have two aspects of privacy, something called the quiet trust, which international families have come to love, which essentially means that they, through the exercise of power granted to the trust protector, can tell Bridgeford not to tell anybody in the public, particularly even beneficiaries, of the existence of the trust. For a wealthy family, that is extremely important, to not have their children know, in many cases, that they're the beneficiary of a couple $100 million trust or $40 million trust. They're worried about if the children were to find out about that, they would not be motivated, of course, to go to college or continue college. And we all know the dangers of wealth, and this is a tool to address that. And really, shouldn't a settler of a trust control who knows what, including the beneficiaries in terms of the asset composition and size and when and how distributions are made? I think it's a very progressive development in U.S. trust law. And I can tell you, it has been one of the biggest drivers of international families, or why international families are coming to the United States. The other aspect of keeping information outside of the public domain, or away from the public, is the idea of a court seal, which means that should any of these trusts find themselves inside of a litigation or part of litigation in South Dakota, and not like very different in other jurisdictions, in South Dakota, there's a total seal, which means that court documents, docket entries, information about the trust, assets, who manages the money, who the trustees are, who the beneficiary, none of that can become public. Very, very important, and very, very important to international families. You juxtapose that with Delaware, which may be the closest in the industry to what South Dakota offers, but they offer a seal for only 3 years. South Dakota, it's forever, and it's discretionary, which means you have to convince a judge that you have a reason to keep the document sealed, or the trust sealed. And I can tell you from my own experience as a fiduciary litigator prior to coming into the trust industry and launching Bridgeford, it's not always easy to convince a judge to do what you want them to do. And I would much rather have the certainty of a South Dakota court system, or I guess statutory scheme, I should say, that seals it forever without having to ask a judge for permission. Again, very powerful and very important. So privacy versus secrecy, I've lingered on that issue because I think it's so important. Again, we talk about the idea of not hiding things from the government, as Forbes magazine points out. That's not at all what we do at Bridgeford. In an attempt to distinguish those who were looking for secrecy instead of privacy, we, along with our fellow trust companies in at least South Dakota, I can attest, do extensive background checks, of course, world checks. Source of funds is vitally important. Of course, verification of good character, tax compliance. And I'll pause on that, and we'll get to this more later, but I have to say I'm very proud of the South Dakota regulators, because in the past 18 months or maybe 16 months, they passed or promulgated, I should say, some uniform guidelines for trust companies in terms of what they expect them to do relative to proper KYC for international families. Trust companies should voluntarily do it, and quite frankly, international families should welcome the questions, because at the end of the day, the information is kept confidential. And more importantly, it protects the integrity, as I keep saying, of the U.S. trust system. And what I love about what South Dakota did is it uniforms it. So meaning that all trust companies are supposed to follow the same rules. So an attorney or a family can't really go anymore shop trust companies in South Dakota and say, well, you know, Bridgeford asks for this, but somebody else doesn't ask for that. So we're going over there to that trust company that seemingly is easier to deal with. You know, that's not in anybody's best interest at all. And it's certainly not in the best interest of the overall trust industry because, again, at the end of the day, what we do for our families around the world is only as good and as powerful as the systems in place in the United States. And if any of us are part of an action that brings harm or reduces the credibility or integrity of the system, then that's not good for anybody. And so we all have an interest to protect the systems in place, which are pretty impressive. Again, I've said this before, I feel very passionate about it. I'm more passionate about it now after the past 3.5 years of the politics in the United States. Not everybody who wants to come to the United States is a bad actor or nefarious. It certainly has not been our experience at Bridgeford. And I had mentioned the uniformity of regulations among trust companies. I just said we have it in South Dakota. I can't speak for Nevada, Delaware, Alaska. Dare I even include Wyoming in that, but I do know that in South Dakota it's uniform. It's been thought out very carefully, all designed to protect families that come here to the United States and the trust industry as a whole. So the transition into modern trust law is very interesting because it really is the engine that drives so much of this, in our view. And from the very beginning of Bridgeford, I have become extraordinarily passionate about what you can do now under modern trust law that wasn't available to me in law school, to planners when I was in law school, as I said, in the late 90s, even in much of the early 2000s. And this is another powerful driving factor of international families into the United States. All of these four concepts are wildly well received by families. And here's why. It delivers more direction and control to families than ever before. So, regardless if the family is from Mexico or China or anywhere in Latin America or Europe, Paramount is of tremendous control. Of course, it is for American citizens as well. But when international families begin to understand just how much they can control relative to trust administration, it makes the decision to come to the United States even more compelling. And of course, the directed trust, in my view, and the view of people around the country in the United States, is really the foundation of modern trust law. I believe that the directed trust, which bifurcates liability and creates the flexibility and control that I'm talking about, which essentially brings us to this chart. And this is basically how it operates. It creates various fiduciary roles, and without getting into the minutia of how it is administered, generally how it works is that it gives the settlers the power and ability to direct investments, including who manages the investments. It gives the settler the ability to create a distribution committee where they can influence more of the decision-making about distributions to themselves and, more importantly, to beneficiaries. And it reduces, frankly, the role and power of an administrative trustee like Bridgeford. And that's fine. That's a good thing, I believe, in our industry. I think it's a very positive development. When I used to practice law and was at large bank-based trust companies, before starting Bridgeford, I was often alarmed, quite frankly, at just how much control a big bank trust company like a Bank of New York Mellon or PNC had over investment decisions and distribution decisions and fee decisions and the unbelievable conflict of interest that existed in managing all those details, in addition to being their private banking, selling them insurance, and having their depository banking relationship. And so this model breaks apart all of that. And we're very proud of it, and we're proud to be part of the new paradigm in terms of how this executes. I'm telling you, this resonates in an amazing way in the international community once practitioners and families understand how this works. And again, in addition to all of the benefits that we've already talked about, then you add this on top of it. And oh, by the way, you have much more control than you ever would have had under old paradigm trust administration. Along those lines, you notice that chart reference a trust protector. This is another mechanism of control for international families. I would argue that the trust protector, in most cases, has more power than the trust company itself, which is, again, a positive development. It's checks and balances. It's making sure the trust company does what it's supposed to do. The trust protector can have up to 18 to 20 specific powers granted to it under the South Dakota statute, which in my mind makes it the most expansive statute in the country. Again, delivering much, much more control to international settlers of trust in the United States. A couple of examples of what can be done is the ability to change Situs, easily replace Bridgeford, easily replace an investment manager, coordinate and oversee distributions, reduce beneficiary interest, add beneficiaries. The powers are extraordinarily expansive. Again, why does that matter? It matters a great deal to a large family that's coming into the United States or a United States-based family. Again, they want to maintain as much control as they can. And in this instance, they can appoint a trust protector that will follow their wishes, quite frankly. And it could be an attorney, their CPA, it could be their brother, their sister, anybody they trust to basically follow their wishes. Again, a tremendous development in modern trust law, and something that we celebrate, endorse wholly at Bridgeford. We're certainly not threatened by it. We like the fact that there's somebody looking over everybody's shoulders and that has the power to replace everybody and change everything, virtually everything, with a stroke of a pen. I think it keeps everybody honest, including the trust protector, including the trustee and the investment managers. And so we encourage it, we again endorse it, and we like it very much to be used in conjunction with the directed trust model. Something that exists only in South Dakota by statute is what we call a trust protector light. Some don't like being appointed a trust protector because of all the responsibilities. It usually is a fiduciary role. It doesn't have to be, but it usually is. Some groups, some individuals get anxious about that. It's a lot of responsibilities. So then South Dakota understood that, and being progressive and nimble as they are, they created a statutorily created position called family advisor, which is limited in power and scope, but nevertheless still delivers much direction and control to settlers of trust to be able to have a family advisor to remove Bridgeford, for example, and they can appoint new trust advisors, investment committee members. Again, there are powers that exist less powerful. That's why we call it the trust protector light, but nevertheless a mechanism of control that can be used. If you have not come across this concept, I encourage you to look at the statute, which is cited on our website. We've written about it extensively. We have a video on it, and there's the citations that you can click on that will take you right to the South Dakota law. I encourage you to look at it. Again, it's a major differentiator. No other state in the country of the United States that I'm aware of has this option. Decanting, it's another control mechanism. It's a way to take trusts that are tired and old and turn them into new, more modern trusts, employing, or I should say implementing, the powerful trust planning, modern trust law options that we've talked about. It works very well in the international space. We can take trusts that are existing and use decanting to move them into the United States. Decanting is something that we use quite frequently to change trustee and to change jurisdiction. Again, the devil's in the details. Not all decanting statutes are created equally, as we'll talk about at the end. Hands down, South Dakota's has been considered to be the most flexible and most liberal, for lack of a, probably that's another word with a negative connotation, but it is one of the most flexible, and is the most flexible in the country, and that's, a commentary by Steve Oceans, a Nevada attorney. He's also the same person who said that South Dakota is the best Dynasty Trust jurisdiction, as we'll get to. So when they use decanting, I've already sort of hinted at this. There's a whole bunch of reasons, whole myriad of reasons why decanting is so powerful, and it really challenges fundamental notions of what is an irrevocable trust. In the old days, which really wasn't that long ago, 15, 20 years ago, and when I was in law school, an irrevocable trust was rigid, expensive, inflexible, I'll say again, expensive, and very little control and direction was delivered to the families, and in fact that's probably why, or not probably why, I think in fact why, the largest families in the country, pushed states like South Dakota to create laws like decanting to give them more power and control and the ability to change trusts. Because as we all know, life changes, especially over jurisdictions and generations more particularly. And the opportunity and the tool to be able to modify these trusts when necessary changes, again, fundamental notions of what is, in fact, an irrevocable trust in the United States. I could tell you internationally, the idea of decanting, again, when explained to an international advisor, is unbelievably well received. They like the flexibility, of course, who doesn't? And so it gives them great comfort to know that they can create a trust in the United States and not have to worry about it never being able to be changed. You know, it's been around since 1992. New York was the first, but South Dakota is the best. And again, that's not the opinion of David Warren or Bridgeford Trust Company, but of people who have been looking at this for many, many years. I've already mentioned why it's important to understand that decanting statutes are not created equally. As I indicated, Steve Oceans, in a very objective chart, explains in specific detail why South Dakota is the most powerful. You know, an issue that has developed that we've been very attuned to is this issue pointed out by the New York Times. You know, in the pandemic and going through all the uncertainty that we've been facing around the world, particularly in the United States, you know, there's collapsing revenue at the state level. Safety net programs like Medicaid and others across the country at the state level has been enormously put under pressure. You know, unlike the federal government, these states can't just print cash, and I don't say that in a pejorative way, but they don't have the ability. They have to actually stick to their budgets, and when they don't have enough money to pay their bills, there's something called a deficit. Like most households, when you don't have enough money to pay your bills, problems happen. And that's what we're seeing happening now as we continue to navigate COVID-19. And the reason why that's become important is because as we do and engage and talk about all of these very important planning tools for international families coming to the United States, it's really important to get the right state now. Because if you pick a state that's suffering and that is in a position that may have to tax trusts and create an income tax at all, well, then all of the great planning that you've done and that these families have paid for goes for naught, because if the jurisdiction turns into a taxable jurisdiction, then now we have to move the trust. And so now there are ways, you know, we can anticipate that, and Bridgeford has gotten involved with carefully looking at various factors in terms of what is it that determines a state's fiscal soundness. You know, South Dakota did not shut down to the degree of other states, maintaining revenue, tax revenue, not creating the type of strain on the safety net program. South Dakota can't even impose a state inheritance taxes or income tax without a 2/3 vote. South Dakota has a balanced budget each year, did again this year with a surplus, even through the crisis. Tax volatility, there is a measure that has looked at this over the last 20 years by the Pew Charitable Trust. They commissioned it and unequivocally found South Dakota to be the least volatile, which is another way of saying the least likely to impose an income tax to make up for problems in their budget. South Dakota's pensions are well over 100% funded, so there's no issue there. I would argue, I'm not sure any other state in the United States can say that at this point. South Dakota entered the crisis in the top 10 in terms of budget surplus. I can only imagine that how high it's climbed up to be closer to number one as we've endured, as states have endured the spending versus income generation in their states. Bank deposits, one of the second largest, I would argue maybe today probably the largest, but at the time we looked at this, 3.16 trillion, way ahead of New York, way ahead of traditional jurisdictions that you would think would have more assets. Various aspects of why South Dakota is strong, even in the middle of the pandemic. South Dakota again was rated a AAA bond rating, which is amazing. I don't know of another state in the country that can say that. Now, here's why we linger over this, and here's why it's an issue that everybody needs to be aware of. Planners, family offices, international families, really anybody looking to do trust planning and looking to the United States, whether within or without, inside the country or whether inside the country or outside the country, is, as we'll see, because we take these ideas and we compare them among the states, the fact that South Dakota is, again, I use the word unequivocally because it really can't be challenged, the strongest of all the jurisdictions fiscally, to me, trumps every other aspect of the nuances of comparisons right now. We can debate how many angels can dance on the head of a pin relative to who might be better at certain aspects. I argue South Dakota is better than in most aspects. But really, when you factor in this worldwide concern and pressure that's facing government, this I think, without question, tips the scale. The scales in favor of South Dakota. So as we've sort of quickly gone through various aspects of why the U.S. and why South Dakota in particular, but probably more generally why U.S. modern trust law, we talk about, well, what do we do? How do we avail ourselves? How do we serve these international families? Why would they come here? And I think we've answered the why. So now let's talk about a planning tool. The most prolific planning tool we see is, of course, the U.S. Foreign Grantor Trust. I always like to understand the conversation when we talk to people, because people kind of get confused when they say we want to do a foreign grantor trust. What that means simply is that the trust is settled by a non-U.S. person, but not subjected to the U.S. tax system or U.S. tax code. But U.S. law still applies. South Dakota law still applies. And it's important to keep that in mind, given the proliferation of international trust companies who have opportunistically come into the United States, obtained Delaware or South Dakota trust powers, and are selling trust services in the international community. Because regardless of their expertise around administering trusts in Jersey or Guernsey or Switzerland or Isle of Man, the reality is they're not U.S. trust companies. And just because they've obtained a U.S. trust charter doesn't make them proficient or experts in U.S. trust administration. A very important point that is burgeoning into a problem, I'm going to say, and we will talk about in a moment. So the Foreign Grantor Trust, we see what it accomplishes. So many of you, I'm sure, on the webinar are very familiar with it, have been involved with it. We know what the advantages are. Again, it gives you the asset protection and the privacy and all of what we say, the proverbial bells and whistles of South Dakota, but does not carry with it the tax burden in the United States. So the question becomes, great, David, let's assume I've convinced you all. Well, the United States is the place to be, and South Dakota is arguably the best destination for these families. How do you get there? How do you make that happen? And there's a couple of key ways to do it, and of course I'm referring to existing trusts. Certainly if you draft a trust or be involved with drafting a trust from scratch, you don't have to worry about these ways of moving trusts into the United States and into South Dakota. Of course, Bridgeford works very closely with attorneys and will help make sure that the trusts comply with South Dakota law. We use South Dakota attorneys who are excellent often to review the trust for South Dakota validity. So that's setting that aside. These are the three different ways to do it. Called domestication, not a complicated process by virtue of changing the governing law to that of South Dakota or U.S. jurisdiction. It's a matter of using potentially decanting to do so, as we've mentioned. That's mechanically relatively simple to do. It's a matter of really appointing a South Dakota trust company like Bridgeford. Once South Dakota law applies, and that happens as a matter of law in South Dakota, once Bridgeford is appointed, the Bridgeford petitions the court and makes the changes that we want, or rather the advisors want and the family wants, turning them into directed trusts, turning them into bringing the privacy aspects, turning them into asset protection trusts, and tightening them up to make them perform in a way that we want and perform consistent with why people are coming to the United States in the first place. Restatement versus modification, there's a best practice. We've seen it both ways. I think most trust companies would agree with me that restatement is probably the most copious way of doing this. Modification is fine as well, but restatement seems to make the most sense because often we have a trust that's been written under the guidelines, if you will, of a Guernsey court system, or rather a trust system, or Switzerland trust system. And sometimes modification is just you can't do enough modification to make it look like and act like and behave like a U.S. trust. So restatement solves that problem. That's what we would encourage. I think that's in the best interest of all involved. Maybe a little bit more expensive for the family, but if we're going to the trouble to come to the United States, hey, why not do it right? ADORA is another way of doing this. We see this a lot. It stands for Deed of Retirement and Appointment of a New Trustee. Bridgeford's become very, very, very knowledgeable in the ADORA structure. We're comfortable with them as long as they meet certain standards that we're looking for. Basically, it's an instrument that makes the transfer, creates indemnification language. And I say substance over form because it's important to get that document correct. And that's really what international families and their advisors rely on Bridgeford for. You don't want your trust company just to sign everything that's put in front of them, just so for purposes of bringing the business in. I said earlier, we all have a huge interest in protecting the integrity of the trust and, by extension, the trust industry. And none of us want to end up on the front page of the New York Times. So the idea here is to make sure we're doing it right every single time. And I would suggest for everybody on this call who works with international families, I think that should be your paramount concern when you're looking at trust company selection. And while you might not love some of the hoops that a company like Bridgeford may ask you to jump through, at the end of the day, you'll be happy should these trusts ever be challenged, or should the U.S. trust jurisdiction as a whole become under attack. So as I mentioned, the devil really is in the details here. I believe that there are really just a handful of jurisdictions that are comparable to South Dakota. We begin with Nevada, and I would argue that Nevada is the closest to being as good as South Dakota. I tell people if for whatever reason they want to be in Nevada, I don't lose sleep over that because generally it's a very strong jurisdiction. There are nuances, though, that are very important to compare and look at. Primarily, Steve Oceans, a Nevada attorney, says that South Dakota is the stronger of the Dynasty Trust jurisdictions. It's kind of important, I think. Again, devil's in the details. You may say, well, why, Dave? Well, I'll tell you why. Community property trust exists in South Dakota. They don't in Nevada, at least not to the codified extent that they do in South Dakota. The decanting statute has consistently been rated as number 1. As I mentioned earlier, again, by the same Nevada attorney, gives a lot of credibility as to why maybe South Dakota is a better choice when you're worried about a decanting statute that you want to be flexible. There's no privacy, or at least not at all close to the extent that South Dakota has. As we talked about, not secrecy, privacy, but a huge driver, nevertheless, for international families who have a desire and a need to be in the United States for privacy reasons. No codified special purpose entity. That is a really interesting tool that we didn't get into today, but a way to add more flexibility and protection of fiduciary roles inside of the directed trusts, particularly also for the trust protector. Happy to talk more about it. Check out our website for more information on the special purpose entity. Again, a real differentiator. Family advisor, we've already talked about it. The trust protector light. South Dakota is the only state in the country that has it codified. Again, a very important differentiator. And finally, state fiscal health. Can't underscore that enough right now as we live through crazy times and the pandemic. Shockingly, Nevada is rated number 29 by the various, by one in particular measure. Troubling, I think, which seems to indicate that perhaps maybe they're not as solid as you would want them to be, particularly if you're going to place a trust there. Clearly that's driven by the fact that the gambling industry has taken a tremendous hit through the pandemic, something to keep our eye on. We know for sure South Dakota is rock solid. I can't say the same for Nevada. Delaware is interesting, and I am often intrigued by people who continue to believe that Delaware is the premier trust jurisdiction in the United States. My partner refers to it as sort of an East Coast bias in the United States. But objectively, and this really does transcend sales, having my lawyer hat back on, it really is interesting to me because, South Dakota and Nevada have far surpassed Delaware at this point. I mean, even if you look at it where it's ranked as a Dynasty Trust, it's not even considered a top-tier jurisdiction anymore, and from a Dynasty Trust perspective by Steve Oceans. Does not have a community property trust statute. Their asset protection statute has a 4-year look back versus a 2-year look back, as I mentioned. The Decanting statute's rated number 3, not anywhere near as good as South Dakota's. The privacy pales in comparison to that of South Dakota. No special purpose, no family advisor. Again, the troubling comparison of state fiscal health, ranked 38th. I get it. If people just have a proclivity for Delaware going into the crisis, understood. It's still a good jurisdiction, just not the best in our view. But again, we should be troubled by the fact that they're not as strong. I think a state should be at least in the top 5 from a state fiscal health perspective if you're going to take the bet. And this ranking says that Delaware today is not a good bet. They've been hit very, very hard by the pandemic on a state level for a whole bunch of reasons that we don't need to get into today. Again, the devil's in the details in the comparison of these states. South Dakota versus Wyoming, I mentioned earlier, I am even more interested as to why Wyoming is ascended, at least by virtue of optics, into the top-tier trust jurisdiction discussion. By virtually all measures, it does not fit the definition of a top-tier trust jurisdiction. Going down the list, it's ranked number 5 as a Dynasty Trust jurisdiction, not even top 4, not even top tier, no community property trusts, 4-year look back on its domestic asset protection statutes. Decanting, it's ranked number 13 by Steve Oceans, an issue. No privacy that we talked about, certainly as compared to South Dakota. No special purpose entity, no family advisor. Probably the most disconcerting of all the state comparisons we've talked about so far. It's ranked 48 in terms of its fiscal strength right now. A problem, a very serious consideration, and something that we have to consider. The exercise of looking at the details and comparative data points may appear to be self-serving by somebody who is an owner of a South Dakota trust company. But in fact, it really isn't as self-serving as it may appear. What has always been at the forefront and the paramount of our concern when we started Bridgeford was to focus on education and objective information to help guide advisors and families making the right decision, whether they're in the United States or around the world. This is objective data. We didn't make up any of this. We just put it into a format that's easy to understand. And in the aggregate, when you easily understand these various factors, it seems to Bridgeford and more commentators, I would argue most advisors, that South Dakota is the strongest of the jurisdictions. So let's linger some more on Wyoming. Why is Wyoming even talked about so much? And I can tell you, I was intrigued years ago while attending STEP conferences. I really like the folks from Wyoming. And I was scratching my head saying, well, why is anybody even thinking about Wyoming? And now I understand. It's primarily the system they've created to have unregulated private trust companies, which means that there's no state regulation. And somewhere along the way, somebody decided that regulation from, say, the South Dakota Division of Banking, for example, is a bad thing. And while it might not be always a fun process, it's essential to making sure that trust companies are operating correctly, that the trusts are being administered correctly. Without some sort of oversight by a regulatory body, how do we know that the trusts are really going to sustain themselves through a court challenge or a tax challenge or an international challenge from a governmental challenge? We don't know that because we don't know that these unregulated trust companies are even operating correctly or funded correctly or their money or they're properly capitalized or properly insured for that matter. I mean, what if the worst happens and the company collapses? Are these trusts protected? Who knows? You don't know because there is no regulator making sure that's the case. Unlike, of course, South Dakota, we get along very, very well with our regulators. They're very collaborative and supportive. Again, it's not always the most enjoyable process, but we always come out stronger. We're regulated every 24 to 30 months They always give us best practices. They always make us better. And frankly, I can't imagine operating in a trust jurisdiction that doesn't have that kind of regulatory oversight. Because it protects not only the integrity of the trust that we manage, it protects the South Dakota Trust Company, the South Dakota Trust industry as an integrity as a whole, and we're going to talk about a quote from the director soon. And if you amplify that, it also protects in large measure the integrity of all of the U.S. trust system, because they're making sure it's being done correctly. The one objection I hear all the time that frankly doesn't make a lot of sense to me as well, but the regulators, that disrupts privacy, and somehow a regulator is going to go and sell their information, and I understand. I'm not insensitive to that concern. I know that in particularly Latin American countries that can happen. That can happen in Europe. That can happen in Asia, and it has happened. Understood. That doesn't happen in the United States. There's not a single case that we're aware of where a regulatory body was ever has breached its duty of confidentiality. So I think that while I understand the cultural concern in that respect, that's not an issue in the United States. And I think the benefits of, as I've already described, of having regulation and having somebody, frankly, looking over the shoulder of the trust company far, far exceeds any infinitesimal or small or unlikely event or I guess likelihood that information is going to be breached by a regulatory body in the United States. As we sort of come to the end of the webinar and summarize all of these ideas, one of the things that I've become again, intrigued. I'm a lawyer by training, so I like to listen to people's arguments, and I like to understand sales versus facts, and I like to understand, arguments and subjective opinions versus objective, again, facts and opinions. And so, I've been looking at this U.S. trust company, like Bridgeford, always been a U.S. trust company from inception, versus an international trust company like a Trident or an Amacorp or others who have come into the United States. They've gotten South Dakota trust powers or Wyoming trust powers, and they're running around the world telling their international clients, look, you don't need to go to Bridgeford or any other U.S.-based trust company. All you need to do is come to us. We'll give you the trust Situs that you want, and everything's fine. Well, that model is not working. I'm happy to have this conversation in a myriad of settings. We anticipate a panel discussion about this at STEP at some point. There's an unbelievable lack of experience and familiarity with regulatory requirements that we've seen with these international trust companies that are coming into the United States. I am not suggesting that they're not good. I'm certainly not at all suggesting they're bad actors. I'm suggesting, though, that trust administration in the United States is vastly different than it is in Switzerland or the Isle of Man or Guernsey or Jersey. It just is. And that is something that has created alarm, frankly, for regulators around the country in top-tier trust jurisdictions. The fact that a lot of these international trust companies, as great as they are, they're performing in-house functions. It's prohibited in the United States. United States trust companies aren't allowed to draft documents. They're not allowed to set up entities. They're not allowed to do certain aspects of legal work that is absolutely happening. That's a problem. Again, I'm not suggesting that the international trust companies don't know what they're doing so much. I'm saying they're not supposed to be doing that. It underserves trusts. I think it places them in jeopardy of being pierced. I think it challenges the integrity of the U.S. trust system. And really, as we talked about, regardless if the trust is governed by the tax system or not in the United States, if a non-U.S. person establishes a trust in the United States, why wouldn't that non-U.S. person want a U.S.-based trust company to administer the trust in accordance with the laws that apply in the United States, and particularly South Dakota? So again, I'm interested. I'm not sure. I don't know if it's sales and marketing over what's in the best interest of these large families. I suspect that's what it is. But U.S.-based trust company, clearly it's a superior option when compared to an international trust company, again, that has come into the United States to opportunistically, frankly, capture business. I do respect them. I think they're all very, very bright people. I think that they just don't have the type of experience and training that we do at Bridgeford. South Dakota Division of Banking has taken this all very, very seriously. We have talked about this earlier. Great quote from the division director, Brad Aftal, has been there for many years. They're the chartering authority. If something goes wrong, we own it. They own it. It's a reputational issue. And no one benefits from having something bad happen, and I take it to the extreme of nobody benefits if somebody or some trust company or some trust ends up on the front page of the New York Times. None of us wants that to happen. South Dakota has done a tremendous job of creating specific policies and procedures around best practices for onboarding and administering trusts that are applicable to trust companies like Bridgeford that operates with and on behalf of international families. And also protects from nefarious actors and protects the overall integrity of the trust industry. Again, I have to say this again because I'm so passionate about it. The amazing ability of a US-based trust solution to serve so many different objectives of an international family is only as good as the integrity of the system overall. All of us, Bridgeford, South Dakota regulators across the country, lawyers, everybody who's working in international space has to do this correctly. Not because we were worried about being fined or losing our trust charter, because we were serving families that are coming here and relying on us to do the right thing every single time. And that is what we're committed to doing at Bridgeford, of course. That is what South Dakota has mandated. And I'm very proud to say that we're very much on the forefront of these issues. So clearly, I think which has been evident in the last 50 minutes or 60 minutes is we're very proud of the position Bridgeford has ascended to in the market working with international families. We're wildly passionate about our capabilities under trust law, modern trust law out of South Dakota. We think the devil is very much in the details as you compare trust jurisdictions. It's important to, I think, separate the fact and objective data from hyperbole and sales, which I've tried to do on this webinar, and I continue to try to do that every time we talk to families and advisors around the world. It's important to get this right. I've said that several times, and that is what Bridgeford is here to do. We encourage you to go to our website. We are very, very active on digital media, proud of our presence, including our fairly recently launched podcast series where we've interviewed some of the top minds in the country, and we have some international top minds that are in the queue to be interviewed, become very successful. We have a very successful blog that has been recognized around the country and frankly has led us to be nominated for various awards, particularly by wealthmanagement.com. And so we're proud of that. We work hard to be objective, to provide education, and those resources are available to you at bridgefordtrust.com. So once again, I'm David Warren, Chairman of the Board of Bridgeford Trust Company. Thrilled to have been able to spend this time with you today. As we end 2020, we look to 2021 with a great deal of hope. I wish all of you a much better 2021. I believe it will be, and we look forward to the opportunity to see you all again soon at maybe a STEP event or somewhere in the world where we're used to congregate. So stay safe, stay well, and we look forward to continued collaboration.